Okay, were we ready with Mr. Dennis's case, Mr. Seeger?
Can be here. Yes, he's lodged back there.
All right, let's take some people that we have here in the courtroom.
I have Mr. Ross, Your Honor. I have Mr. Farmer. I have Mr. Tushby.
Okay, Mr. Ross, you come forward to the podium, please. Go on the record in People versus Darnell Ross. This is file number 255094. The record should reflect Mr. Ross is present here in the courtroom. Executive counsel put your appearance on.
Ryan Ziegler on behalf of People.
Thomas Seeger appearing with and on behalf of Mr. Ross.
This is the date for a final status conference in this case, and a plea cutoff. We currently have trial set to begin on February 18th. Mr. Seeger has been able to talk to Mr. Ross about how he wants to proceed.
I have, Your Honor. Your Honor, it's my understanding that Mr. Ross wishes to proceed to trial and is demanding I did speak with the prosecuting attorney. He probably has a request that he would like to make, which I would oppose, but I'll put those reasons on the record following his request if he makes it.
Okay, Mr. Ziegler.
Your Honor, we would be requesting an adjournment of trial. The reason for the adjournment is the court sent out the notice for trial back in November. I reviewed the file in December. I sent subpoenas to the witnesses, and I noticed that we just had a true narc in the file. We did not have the full laboratory report. So my staff sent an email to the officer asking him to get this to the lab as soon as possible. We followed up with him in January, again, asking where we were at on the labs, if they'd be available. We got no response. We called the post yesterday and spoke to a sergeant over there. They informed us that the suspected drugs or paraphernalia were never sent to the lab for testing. So it's unlikely that we are going to have the lab report in the next 2 weeks. Therefore, I'd be asking for an adjournment of trial.
Mr. Seeger.
And I guess my response is, I do understand that things happen, and I'm not saying that Mr. Ziegler's office didn't make that. But what I am saying is that the matter's been pending for an extensive period of time, which like prior to November, because the matter was bound over well in advance of that. So they've had all this time to get their ducks in a row. They've had all their opportunity to get whatever evidence advanced. It's their burden of proof at all times. He has the right to a speedy trial. He has the right to due process. If it's through their own error or malfeasance, and not Mr. Ziegler's malfeasance, but if it's by virtue of negligence of the charge officer, that's on them. I can't think that, at least in terms of case law, I can't think of that being good cause because the officer was lazy and didn't secure evidence that was requested by the prosecuting attorney's office. That's not good cause. Good cause might be something like if there was a witness who was unavailable for some reasonable reason. This is a situation wherein law enforcement has failed to provide certain evidence that is necessary for the promotion of their case. So if they're able to provide it by February 18th, then I'll examine it. I still think that that's probably not a sufficient period of time because that document should have been provided to me a long period of time ago. And that was part and parcel of my defense that there was a missing lab. But again, I'm not here to curate proofs for the prosecuting attorney either. The only thing I can say is he's demanding the trial. It's set for February 18th. As far as I can tell, there's no good cause to adjourn. If the court finds otherwise, I would just ask the court to create a record as to why that is good cause. But again, Mr. Ross wishes to execute the speedy trial rights. And it's not as if this is a situation wherein, the notice hadn't gone out for a long period of time. This has been set for around November. So they've had plenty of time to get whatever evidence it is that they need to proceed with their case, which for whatever reason they failed to do. And that's on them. If they proceed to trial without it, then they proceed to trial without it. It may also be the case if the prosecuting attorney does something else. But either which way, Your Honor, it's my understanding that Mr. Ross wishes to have his trial on the 18th and scheduled that way. So unless there's good cause to adjourn it, which I don't see any good cause, I would just ask the court to deny.
All right, thank you. In order to grant an adjournment, the court does have to find good cause. there's a couple factors I think here that are relevant to the court's consideration. Number one, Mr. Ross is not incarcerated. I think if he hadn't been able to post bond and was lodged, there's a much greater urgency, and certainly the case with that priority in terms of going to trial. So with Mr. Ross being out on bond, the court finds that adjourning the matter doesn't necessarily result in any prejudice to the defense. The court does know that this matter was set for a trial. The trial dates were set and sent out in December following a November status conference. And based on Mr. Ziegler's representations to the court, which I have no reason to disbelieve, there has been diligent efforts on the part of the prosecution to obtain the testing and evidence that they need to be ready for the trial date on February 18th. So the court doesn't find that there's been any lack of exercise of diligence on the part of the prosecutor's office. Also, the court generally grants adjournments pretty freely to the defense. They're very rarely requested by the prosecution. And this is the first request for an adjournment. Finally, the court would note that, again, the clock really started running on this case in terms of timeliness, in my view, in November when the trial was requested. So we're only a couple months out from that. Mr. Ross was bound over in mid-September. So as these things go, there hasn't been a terrible amount of delay in this case, such that the court finds there would be prejudice to the defense. So for all of those reasons, the court finds there is adequate cause to grant the adjournment. The court will reset the trial as well as another final status conference for a one-day jury trial. The court is unlikely to grant any further adjournments for testing. So Mr. Ziegler, whatever you need to do to spur that on will need to happen for the next trial date, and then we'll go forward at that time. Mr. Ziegler, I would just request that you prepare an order reflecting the motion on the record here today, as well as the court's ruling, and submit that under the 7-day rule or with the stipulation as the form.
Yes, sir.
Okay. Mr. Ross, it's important that you continue to stay in touch with your attorney, and will be provided with the notice of the date and time of that next hearing date. Okay. All right. Thank you. That's all.
Thank you. Then your Mr. Farmer is also in the program.
People versus Farmer, file number 255130. Mr. Farmer, come up to the podium there, please. The record should reflect Mr. Farmer's present here in the court today. I'd like to have counsel put your appearances on in this file.
Ryan Ziegler again.
Thomas.
I have this set for a plea hearing today. Mr. Seeger, how did you want to proceed in this case?
Sure. At this time, Mr. Farmer indicated that he wishes to proceed the trial. I would note that he's rejecting the offer where he was offered an opportunity to plead to one count of lewd and lascivious, which would have been a 1-year misdemeanor. Most notably implicit in that is that there's no SORA requirement related to that. But to that end, Your Honor, he wishes to proceed to trial.
Mr. Ziegler, how much time do the people need to be ready for trial in this case?
We could be ready within, or at least 60 days, Your Honor.
Okay, Mr. Seeger?
That's fine. Yeah.
Okay. And Mr. Ziegler, how many days of trial would we need in this case?
Your Honor, even though it's a criminal sexual conduct case, I probably only have 2 or 3 witnesses. I think we could get it done in 1 day.
Mr. Seeger?
I agree.
Okay. So we'll set it for a 1-day jury trial. I'm going to put the time frame as 60 to 90 days. The court will set this for a final status conference prior to the trial date. So, Mr. Farmer, there'll be one final hearing here in court before we have your trial. And that hearing date would be the plea cutoff, so that to the extent that you wanted to further consider any plea offers, that would be the last day to enter into any plea agreements, okay?
Okay.
Also, that'll be the motion cutoff, so to the extent that either side has any motions, they need to be filed and set for hearing no later than the date of that final status conference. And Mr. Farmer, you'll be provided notice of the date and time of that hearing as well as your trial date. Between now and then, it's important that you stay in touch with Mr. Seeger so that you're prepared to go forward on both of those days, okay?
Yes, sir.
Do you have any questions at all?
No, sir.
Okay, thank you. That's all for today.
Then I have Mr. Bishke in the courtroom there.
People versus Bishke, case number 255135. The record should reflect the defendants present here in the courtroom today. If I could have the council put your appearances on in this file.
Brian Ziegler, on behalf of the people, Your Honor.
Thomas Seeger appearing with an on behalf of Mr. Bishke.
And Mr. Seeger, how did we want to proceed in this file today?
Your Honor, it's my understanding that Mr. Bishke is going to tender a plea to aggravated domestic violence in exchange that this is instructing.
Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Bishke, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes.
And is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Bishke, are you currently on any kind of probation or parole?
No, not yet.
And you understand that the maximum possible penalty you could face for aggravated domestic violence is up to 1 year and or $1,000 fine?
Yeah.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights,
Yes.
and you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes.
Did you have any questions about that?
No.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to this crime because you are actually guilty?
Yes.
The information I have indicates that this happened back on November 14th of 2025. Is that the correct date?
Correct.
And on that date, did you have an altercation with an Ashley Martinez?
Correct.
And were you residing in the same household as that individual? Did you have a dating relationship with that individual?
Yes.
And what happened during that incident that would make you guilty of this crime?
We got into an argument and I shoved her and she fell and hit her head. And that was that.
Okay.
And then she left.
All right. And where did that happen at?
In the kitchen. Area.
Okay, of your residence?
Correct.
And is your residence located within Kalkaska County?
Yes.
Mr. Ziegler, are the people satisfied with the factual basis?
Your Honor, there needs to be some testimony as to an aggravated injury requiring medical attention.
Oh. So she hit her head, is that correct?
Correct.
Okay, did she need to get some medical attention for that injury?
Yes.
Did she cut her head or what was the kind of?
She fell back and hit her head on the counter of the sink in the bathroom.
Okay. Did she have to get like stitches or something like that?
4 or 5 staples.
Okay. All right, with that, Mr. Ziegler,
I'm satisfied.
Mr. Seeger.
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you, sir. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date, time of that hearing. Ms. Wagner, do you want Mr. Bishke to stop by the probation office today?
Yes, please. Thank you.
Okay, so Mr. Bishke, before you leave today, go next door to the probation office and check in with them. And make sure that you stay in touch with Mr. Seeger prior to that sentencing hearing, okay? Did you have any questions at all? Thank you, that's all. Okay, can we get Mr. Dennis? Who that was at Wexford, Mr. Seeger?
That was Mr. Griffith, which is Mr. Gurman's client.
They're at Wexford. Can you unmute, please? Thank you. All right, we'll go on the record in People versus Griffith. This is file number 255101. Mr. Dennis, you can go right to the podium there. We're going to take care of one thing before we start yours. The record should reflect Mr. Griffith was present today by video from Wexford County Jail. If I could have both counsel put your appearances on.
Ian Ziegler, yeah, for your honor.
Good morning. Thank you, Honor Ravigar Murthy. I'm appearing on behalf of Mr. Griffith.
All right, this is set for a final status conference today. We do have trial set to begin in this matter on February 18th. This is also the plea cutoff. So this is the last date to enter into any plea agreement prior to trial. Mr. Gurmurthy, have you been able to discuss that with your client?
I have, Your Honor, and we've had some extensive discussions. I've had some extensive plea negotiations with Mr. Ziegler's office. We've reached a resolution. My understanding is Mr. Griffith would enter a plea of no contest to 6 counts of felonious assault. The remaining 9 counts in the felony information would be dismissed. There is no sentencing agreement, Judge.
Okay, and what would be the reason for the no contest plea?
A potential civil liability, Judge, and Mr. Ziegler and I did previously email Ms. O'Rourke at your office a copy of the transcript of the preliminary exam that establishes factual basis for the no contest plea for those 6 counts of felonious assault.
All right, thank you. Mr. Ziegler, is that a correct statement of the plea offer in this case?
It is, your honor.
Okay. Mr. Griffith, were you able to hear all of that?
Yes, Your Honor.
And have you had an adequate opportunity to speak with your attorney about this plea agreement?
I have, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Griffith, are you currently on any kind of probation or parole?
No, Your Honor.
All right, and you understand that for each count of felonious assault, that the maximum possible penalty you could face would be up to life. I'm sorry.
4 years and or $2,000, your honor, for felonious assault.
4 years, sorry.
That's correct, Judge. It's 4 years and a $2,000 maximum on the 4-year count.
Okay, so Mr. Griffith, you understand that that is the maximum possible penalty for each of those counts?
Yes, Your Honor.
With that maximum possible, is there any, Mr. Gurmurthy or Mr. Ziegler, are either of you aware of any potential consecutive sentencing sanctions in this case?
I am not, your honor.
And neither am I, Judge. There should be no consecutive sanctions in this case.
Okay. So, Mr. Griffith, with that maximum possible penalty in mind as to each of those charges, what is your plea here today?
No contest, Your Honor.
All right. Right now you have certain rights, Mr. Griffith. I'm going to go through those rights with you here on the record. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all those rights,
I do, Your Honor.
and you understand that you're going to be giving up and waiving all of those rights by pleading no contest, and you won't have those rights anymore, including that right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of that appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
And is it your own free choice to enter this plea?
Yes, it is.
All right, so based on the stipulation of the parties and the stated reason of the potential civil liability, given the nature of the charges in this case, the court finds that that's an adequate basis to accept a no contest plea. I also did receive, as indicated by Mr. Germer, the transcript electronically. I had a chance to review that transcript prior to the hearing today. Mr. Ziegler, have you reviewed that transcript?
I have, Your Honor.
Would you agree that the testimony contained within that would establish a factual basis for 6 counts in this case?
I do.
Mr. Germerthy, have you done the same?
Yes, sir.
Would you agree as well?
And I would.
All right, Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Germerthy, are you?
No.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Germerthy?
I concur.
Thank you. Mr. Griffith, the court finds that your plea is knowing and voluntary. I'm satisfied based on my review of the transcript as well as the stipulation of the lawyers that there is testimony in that transcript that would establish a factual basis for a finding that you are guilty of 6 counts. The court will accept your no contest plea as to all 6. We will set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll be contacted by the probation department for a pre-sentence investigation. Once they prepare that report, you'll have an opportunity to go through that with your attorney, and then we'll set this for a sentencing hearing. Do you have any questions about how we're going to proceed with your case?
No, Your Honor.
And then finally, the court will adjourn. The trial date's currently set for February 18th through the 20th in light of the plea here today. Mr. Germerthy, anything further on your client's behalf?
Two things, Judge. One, I would like to be present at the pre-sentence interview with my client. I know Ms. Wagner and Ms. Welkeron, so I know one of them will reach out to me to schedule that, but I wanted to just inform them that I'd like to be present. Second is, Judge, I'd like to argue bond on behalf of my client. Bond with the original charges, understanding that that's what he was charged with, was set, I believe, at about $8 million. Mr. Griffith has been cooperative. He has accepted a plea to the felonious assault. I would ask that bond be modified accordingly. Mr. Griffith has no prior criminal record. I've been in contact with Mr. Griffith's wife, who lives in Kalkaska County. He has 2 minor children. I think one is 2.5 and one is about 6 months old. Mr. Griffith is not a flight risk. His property is in Kalkaska County. He is a resident of Kalkaska County, has local ties to the community through friends and other individuals through his homestead. Certainly, Mr. Griffith is not opposed to being on any sort of GPS monitoring or tether. He would abide with the no contact orders that the court would impose. There is no concern of drugs or alcohol with Mr. Griffith, but certainly if the court requires Mr. Griffith to comply with any pretrial services, he would do so as well. I would argue that in this matter, that the bond be set at 20,000, 10% to secure Mr. Griffith's appearance at sentencing. And Mr. Griffith is going to appear at sentencing. I have no issues with him being a flight risk judge.
Mr. Ziegler?
Yeah, I think regardless of whether the plea is to the 9 felony counts that were initially charged, or the 6 felony counts that he's pled to, it's clear that this is a serious offense. It's an offense that involves endangerment of the public and of the victims particularly. I do agree that a bond of 8 million cash or surety probably would not have been warranted had we started with just counts of felonious assault, but that's not how this case has developed. I believe, and the guidelines are always subject to the court's approval, but my belief is that the guidelines for the felonious assaults are going to be 5 to 23. It's very likely that Mr. Griffith will still have to do some additional time, depending on what the court sentence is, obviously. And so I don't think that a modification of bond at this time is warranted.
All right, thank you. Mr. Griffith, there's a number of things that the court has to take into consideration when it comes to the amount and conditions of bond. Number one, I think there's been a plea in this case, so we're no longer in a pre-trial type posture here. Mr. Griffith has pled guilty, so it's no longer a question of guilt or innocence in this case. I mean, he's pled no contest, but he's accepting responsibility for these crimes. So I don't find that Mr. Griffith would be entitled to pretrial release at this time regardless. But the court finds that given the nature of these crimes, which are assaultive, there are numerous offenses here that Mr. Griffith's pled no contest to, regardless of amounts or conditions. The court finds that it would be in the interest of public safety to have bond remain where it is pending a sentencing hearing in this case. The court also agrees with Mr. Ziegler in terms of a potential sentence. If those are the guidelines, it's likely that Mr. Griffith is just going to continue to accrue credit for a sentence that he would ultimately be required to serve. So for all those reasons, the court finds that bond should be, the motion for modification of the bond should be denied. The bond will remain as set. And again, we'll set this matter for a sentencing hearing at the court's next available date. So aside from that, Mr. Gurmurthy, that sentencing hearing will be in person. So I'm going to request Mr. Griffith will obviously be brought here. I'm going to request that you're present here for the sentencing hearing as well, in case he has questions or needs to go through things with you. That'll be easier to do if you're here.
Yes, sir.
In light of the original information, Mr. Ziegler, and the plea agreement here, I am going to ask that you prepare an amended information with the new counts added to that, so that just given the nature and the number of charges here, I think it'll be cleaner for the file as opposed to trying to just do that for the record. Can you get that filed with the clerk's office today?
I believe so.
Okay. Mr. Ziegler, anything further from your standpoint here?
No, you're right.
Mr. Gurmurthy, anything further today?
No, sir. Thank you.
Okay. All right. Thank you. That's all for this hearing today.
Thank you, Judge.
All right. People will call people versus, I'm sorry, the court will call People versus Lloyd Dennis. This is file number 25-5118. Dennis is present here in the courtroom today. This is the date and time set for sentencing in this matter. If I could have counsel for your appearance.
Thomas Digger, apparently on behalf of Mr. Dennis.
Dennis, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger about that? Okay. Mr. Seeger, are there any additions, deletions, or corrections to that report?
They're not.
Are there any challenges to the scoring?
Not by me here.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, you're right.
Any challenges to the scoring?
No, you're right.
Anything on behalf of the people for elocution today?
Your Honor, I think the recommendation of the jail sentence in this case is appropriate. Mr. Dennis was on probation at the time of this offense. He relapsed and he was charged with possessing fentanyl. His track record on supervision is poor. He did not complete residential treatment. He did not comply with probation terms, and he failed to appear as ordered for his PSI interview. A probationary sentence in this case would accomplish very little. As such, his track record warrants a sentence that sends a message to him that his continued controlled substance use and his continued violations of court orders and court supervision will have serious consequences. I would ask the court to impose 6 months in the county jail with credit for 33 days served.
Thank you, Mr. Seeger.
And Your Honor, just on behalf of Mr. Dennis maintains that he did in fact complete treatment. Whether or not he did, I don't have any verification of it, but he is representing that he did. But probably what's more pointedly important is that Mr. Dennis indicates that he understands that he has a substance abuse problem for which he wants to get back into a treatment type setting. Unfortunately for Mr. Dennis, he has other problems because he still has to deal with his Benzie County case, which has a great penalty. It's difficult in these cases because in most instances, people who have substance abuse problems do have relapses, just like Mr. Ziegler said. This is not a situation wherein Mr. Dennis is alleged to have been selling drugs. He's probably more of a danger to himself than he is to the public. And unfortunately for him, he needs to continue to work on maintaining his sobriety, which I think he's struggled with for a variety of reasons, some personal reasons, a lot of different reasons, but he's trying to stay on the straight and narrow. He recognizes that he has struggled at times. He recognizes that jail may come from this. The recommendation, the guidelines are 0 to 9 months. The recommendation is for a jail sentence. He served 33 days. I would ask the court to consider closing this file without further incarceration. He clearly will have to go back to Benzie County and address his underlying probation violation and a much greater charge. This is really a case of probably mail that will hit him. Unfortunately for him, in Benzie County, he's on 7411. I suspect, albeit I don't want to speak for the court over there, that there's probably a good opportunity that he's going to lose his 7411 status for him as the court. And that would probably be the greater punishment. Whatever it is that the court does, he's hopeful that the court will allow him to get into treatment, which he clearly needs, which one way that he'll be able to accomplish that is presumably through a sentence in Benzie County if they afford him that opportunity. But if the court sees fit to allow or to sentence him to some kind of jail time, he would just ask that a condition of his sentence allow for him to get into treatment to the extent that Benzie County allows him to get into treatment. The other problem, Your Honor, would be that I suspect that in Benzie County, he's probably more likely to face a greater amount of jail time than he would be here. If we sentence him, theoretically, we are probably holding him for the benefit of Benzie County. But that doesn't mean that there's not a punishment for his own act. Just as a matter of practice, it seems as though logically that perhaps Benzie County, if there is a punishment, it is resolved through this underlying probation violation, at which point it would be their responsibility to house him. And if he's able to get treatment, which he's indicated he wishes to do, that would be helpful to him and everyone else. So he's just asking for that opportunity.
Thank you. Mr. Dennis, anything you wanted to say today?
No, sir.
It's been a long road. All right. I did read through the report, so I'm familiar with what happened in this particular case, as well as just your general circumstances and your past history and so forth. And so I take all of that into account, along with what the lawyers had to say here on the record today. It sounds like your probation in Benzie hasn't gone real well. And certainly this is not helping things, this additional charge here. Based on the information contained within the report, I mean, I'm satisfied that you do have a substance abuse issue that you do need to work on. The question is whether we're going to continue to put court resources towards that, or whether that's something that you need to do on your own because you want to stop going to jail and you want to just live a better life for yourself. In this case, I agree with the recommendation that further probation here is not going to be helpful either to you or to the community. I think to the extent that Benzie's willing to continue you on probation, then that's where that should occur, as opposed to here in this case and adding an additional term of probation on. I also think that while it appears you've made some requests to get treatment and have at least attempted treatment in the past, and this report indicates it wasn't successful. I don't have any information, one way or the other. But certainly the report documents, a lot of failures on bond, a lot of positive drug screens and so forth, or just non-compliance, which indicates to me that even though you're expressing a desire to get treatment, you're not following through with any of those expressions, or not doing anything to get yourself in a position where that can happen, or where the court would be willing to order that or make that part of the sentence. So I think you need that. I think it's something that you're going to need to do on your own, rather than being ordered by the court to do it, because I don't think just the court ordering you to do it is going to make it happen. I think you've got to make that decision inside yourself that that's what you want and take the steps to get better. In this case, I think given your total circumstances, the guidelines are 0 to 9 months. I think a reasonable sentence is 5 months in the middle of that guidelines. I think that accounts for your failures on bond and for your conduct in this case, but also is shorter than the maximum sentence under the guidelines, and will give you an opportunity to seek treatment sooner than you might otherwise be able to. So the court is going to sentence you to 5 months in the Kalkaska County Jail. You do have credit for 33 days served. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence. We're going to provide you with some papers, Dennis, that explain to you what your appellate rights are, as well as how to request the court appointed attorney.
For the record, we're trying to support our rights.
Rather than to the custody account at this time. We have Mr. Yoder present.
Your Honor, he's lodged in the Webster County Jail. I do have one other person here, Mr. Sherwood. This is Mr. Yoder.
Okay. All right, Mr. Yoder, are you able to hear me okay?
Yes, sir.
All right, we'll go on the record in People versus Yoder. This is file number 244973. The record should reflect Mr. Yoder's presence by video from Wexford County Jail. If I could have counsel put your appearances on.
Thomas, with it on behalf of Mr. Yoder.
Mr. Seeger, can you tell me the status of this file this morning?
Your Honor, and I think that the circuit court clerk brought over an additional file that was not originally on the docket. So I'm not sure what that case number is, Your
Honor. 265158. So we'll call that file as well.
In any event, Your Honor, it's my understanding that the people have offered Mr. Yoder an opportunity to plead to 1 count of impaired and then 1 count of possession of methamphetamine, which would be treated under 7411.
Okay, so in file number 244973, that would be an added count 4 of operating while impaired. Correct. And then plead as charged in the new file.
Plead to count 1, count 2, the no insurance would be dismissed, Your Honor. It would be handled under 7411.
And Your Honor, did you say it was 5158?
265158, yes. Okay, so Mr. Ziegler, that's correct.
It's correct statement.
All right, Mr. Yoder, were you able to hear what we said about the plea agreement?
Yes, sir.
Have you had an adequate opportunity to discuss that with Mr. Seeger?
I have.
Is that how you wanted to proceed today? Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Yoder, are you currently on any kind of probation or parole?
No, sir.
All right, and you understand that by pleading guilty to operating while impaired, that's a misdemeanor that carries with it a maximum penalty of up to 93 days in jail and or a $500 fine?
Yes, sir.
And that by pleading guilty to possession of methamphetamine, that's a felony that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine?
Yes, sir.
With both of those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And do you understand that you're going to be giving up and waiving all of those rights by pleading guilty?
I do, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to plead guilty?
It is.
Are you pleading guilty because you are actually guilty of each of these charges?
Yes.
So first, talking about the operating while impaired charge, the information I have indicates that happened back on September 15th of 2024. Is that the correct day?
Yes.
On that day, had you been consuming alcohol?
I had.
After you consumed alcohol that day, did you operate a vehicle on Twin Lakes Road here in Kalkaska County?
I did.
Did you have any blood or breath tests to determine the level of alcohol in your system at the time that you were operating that vehicle?
I did a breathalyzer.
Was the result of that higher than a 0.08?
It was.
Do you have any reason to doubt the accuracy of that test?
I do not.
Do you believe that you had consumed enough alcohol before you drove on that day that the use of that alcohol impaired your ability to safely and normally operate that vehicle?
I do.
All right. The other charge, possession of methamphetamine, the information indicates that happened on July 13th of 2025. Is that the correct date on that?
Yes, it is.
On that date, were you present here in Kalkaska County?
I was.
And did you have possession of some methamphetamine at that time?
I did.
Did you know that that's what that substance was?
I did.
Did you have any legal right to have any amount of it at that time?
I did not.
Have you ever previously been convicted of any offense involving controlled substances?
No, sir.
Okay. All right, Mr. Ziegler, as to both charges, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you. Mr. Yoder, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. Between now and then, you'll meet with somebody from the probation department to conduct a pre-sentence investigation. They'll prepare a report and you'll have an opportunity to go through that with your attorney prior to the sentencing hearing. Mr. Seeger, anything further we need to address?
Your Honor, Mr. Yoder was hopeful that the court would consider amending his bond. I did discuss this matter briefly with the prosecuting attorney, for which his position may be somewhat different than mine. But in any event, Your Honor, because we have conceded that his sentence would be treated under 7411, it's not to say that the court couldn't impose jail time under 7411. It's that the court does not ordinarily do it. And I assume the reason why Mr. Yoder has been offered this opportunity is because he's eligible for it and he appears to be a good candidate on probation. One of the things that would be helpful to know is whether or not he's able to be compliant with the objects of his bond. From my standpoint, Your Honor, I mean, in some instances, it's better that the client remain lodged because then I know that they're not going to mess up their bond in any way. On the other hand, Your Honor, I do recognize that people have things that they need to accomplish and that being incarcerated probably doesn't help you accomplish those things. And later, if the court is considering granting somebody the ability to be placed on 7411 probation, presumably they've done reasonably well while on bond. So I would like to believe that that's going to be the case for Mr. Yoder. He does have good family support. His family is in the courtroom. He did indicate that he would appear in court whenever required to do so. There's no allegation that he was selling drugs of any kind. It was just apparently that he was possessing them. And so to that end, Your Honor, I would just ask the court to consider giving him the PR bond with the idea that the court would probably not look at things favorably if you get out on bond and you're not following through with the requirements of it, i.e. that you need to follow up with probation, parole, i.e. that you need to do your drug screens once weekly. All those things are probably likely conditions of probation. So to that end, Your Honor, somewhat quasi probation for him in advance of sentencing, not presupposing that the court will honor the sentencing agreement.
All right, Mr. Yoder, one of the factors I think here that's prominent in my mind is the fact that you failed to appear back in December of 2024. And then again in January, early January of 2025, you weren't arrested. Bench warrant was issued. You weren't arrested on that until just about a month ago, January 12th of 2026. So you remained at large for a period of about a year while these charges were pending. During that period of time, you accrued another criminal charge that you just pled guilty to today. And at no time during that period did you turn yourself in or attempt to get this matter taken care of. Despite the fact that you've entered pleas here today, I have no assurance that if I let you out on a PR bond that you wouldn't just disappear again for another year. So there's really no reason for me to grant you bond at this point, given the fact that you absconded for such a long period of time. So based on that, the court. Yeah.
It's my understanding that there was an error in the clerk's office and that my warrant was never actually issued. It was never sent to the law enforcement agencies. I was never aware of that warrant. I never received any paperwork on it or anything.
All right, well, you were aware that you had a felony and 2 misdemeanor charges against you, right?
Yes, sir.
Did you ever call your attorney during the period of that year to say what's going on with my case? I'd like to get this taken care of.
I believe I tried to when I went to the Social Security office and they wouldn't issue me another license or anything.
Okay. So
I just wasn't sure.
does any of that mean that you could just ignore your charges for an entire year and not contact the court at all?
No, sir.
Okay. So again, none of what you're telling me here makes it to me any more likely that you wouldn't do the same thing and have multiple excuses just like you do here right now for not appearing. So none of what you said to me is a good reason for just disappearing for over a year. So the court's decision remains you will be held without bond pending the sentencing hearing. We'll get that on the calendar as quickly as we can, and we'll proceed with your case at that time. That concludes this hearing. The court's going to disconnect at this time. Thank you.
Can I get the PAC code for that count 4?
Yes, just 1 second.
Sure.
I think I know it, but I'll check. All right.
Mr. Seeger, do we know anything about Mr. Patrick's?
Your Honor, in between court, I had walked over to talk to the probation department. I think that they were asked to pass the matter or adjourn the matter another day. To a certain extent, or I think that the case theoretically is going to be resolved by virtue of his compliance in another county. I would defer to Ms. Wagner, whatever thoughts are.
Ms. Wagner, have there been any updates since earlier this morning?
Your Honor, he did reach out to me just recently. It sounds like he's working in East Jordan. He started a new job for some reason. I don't know why. He thought he had court on the 6th. He's still on probation in district court, and he's scheduled to report to circuit court probation tomorrow in Antrim County where he lives. So I will get things kind of confirmed and wrapped up of what is going on and what he's been doing and not been doing. So if we can pass this matter for the next month so we can have it better resolved, I would, that would be good. Thank you.
Any objection to that?
No, Your Honor.
Okay, so this is People versus Patrick, file number 244981. The court will reset this for a probation violation hearing on the March motion day, and we'll go forward with it at that time. Okay.
Thank you.
Yes, Mr. Sherwood.
He is.
Mr. Sherwood, if you come forward, please, to the podium. We'll go on the record in People versus Sherwood. This is file number 255132. Reflect Mr. Sherwood present here in court today. If I could have counsel for your appearances on.
Brian Ziegler,
Tom Seeger appearing with on behalf of Mr. Sherwood.
Seeger, can you tell me the status of this file?
Your Honor, it's my understanding that the people have offered Mr. Sherwood an opportunity to break down the attempted resistance structure. All of the counts.
Mr. Ziegler.
Fair statement, Your Honor.
Mr. Sherwood, have you had an adequate opportunity to speak with Mr. Seeger about this plea agreement?
A little bit.
Would you like?
Showed up a little bit late.
Okay. Would you like some more time to do that before we go forward?
No. Okay.
Did you want to proceed with that plea agreement here today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Sherwood, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to attempted resisting or obstructing, maximum possible penalty you could face would be up to 1 year in jail and or a $1,000 fine?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
I do.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty to this charge because you are guilty?
I am.
The information I have indicates this happened back on November 11th of 2025. Is that the correct date?
Yes.
And on that date, did you come into contact with a Deputy Hawkins or Deputy Beaver here from the Kalkaska County Sheriff's Department?
Yes.
Did that encounter occur somewhere here within Kalkaska County?
Yes.
All right, and what happened that would make you guilty of attempted resisting or obstructing?
I did not leave the scene when prompted to. I was given an opportunity to leave the scene, dealing with my son at the time, and we had an altercation, but he has since been evicted from the house, and I don't know where he's at now.
Okay, so they were there investigating an altercation between you and your son?
Yes.
And as part of that investigation, ordered you to leave that premises. Okay. And were they doing that to try and separate the two of you, or?
I do believe so.
Okay. And you said that you didn't follow that direction.
No, sir. I wanted them to deal with his problem. I'd caught him previously using methamphetamines in my mom's house. So I attempted to deal with it myself and did not do it right.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, Your Honor. Your Honor, additionally, people don't have an objection to immediate sentencing unless the court wishes to have a formal pre-sentence report.
Okay. Mr. Ziegler, any objection to going forward with sentencing here today?
No, Your Honor.
Okay. Before we get to that point, all right, are you both satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
Yes, sir.
Okay, so Mr. Sherwood, the court finds your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of attempted resisting or obstructing. The court will accept the plea. Your lawyers indicated that we could move forward with sentencing here today. You do have the right to have a pre-sentence report prepared and have this set on a separate date. But do you have any objection to going forward here today?
No, sir.
Okay. Mr. Ziegler, are you going to be asking the court to impose any jail time as part of the sentence?
No, Your Honor.
Okay. Is there anything that you wanted to say then for allocation?
Your Honor, this is a circumstance where officers responding to an alleged domestic violence situation. Mr. Sherwood was intoxicated. Seemed to want to comply with the officer's commands to stay separate. At some point, they decided to place him into handcuffs. He did not want to comply with that either. They gave him several commands. He refused to follow those. They eventually had to physically grab his arms and force him to the ground, at which point he complied with the handcuffing. I don't believe anyone was injured as a result of that. Mr. Sherwood has not been in any trouble in about 9 years. He does have a few misdemeanors on his record in the state of Michigan, no felony history. I do think that this was just a very poor decision by Mr. Sherwood. He was intoxicated and he did not handle the situation appropriately. But given his lack of history in the past 9 years, I don't see that there's any point to jail or probation under these circumstances. I'm just hopeful Mr. Sherwood has learned his lesson from this incident and hopefully will handle things better in the future. I think a sentence of fines and costs is sufficient at this time. Thank you.
Thank you, Mr. Seeger.
Yeah, likewise, I would just ask the court to consider limiting this to full cost and fines. I know Mr. Sherwood from, I think his life has changed significantly. He was going through a hard moment. Clearly, he should have listened to law enforcement. Quite honestly, Your Honor, and he'll acknowledge this, that there was a moment where he could have left and it would have been nothing. Instead, he chose to continue to have a disagreement with law enforcement, which he should have just left. But he didn't. Instead, but to that end, Your Honor, he's generally done well. Sorry that this has all happened. He had expressed to me that he was trying to address a substance abuse problem with his son. It clearly didn't go very well. But again, when law enforcement are there, it would be much better to follow the commands of law enforcement. Should he ever pick up a felony somewhere in the future, hopefully that's not the case. This conviction allows them to habitualize him. So hopefully this is a learning lesson for him. But given that there's been a great amount of time that has elapsed since his last conviction, I assume that he's not likely to come back. He did indicate that he just wishes to put this behind himself, and he said that.
Thank you, Mr. Sherwood. Anything you wanted to say today?
No, Your Honor.
Okay. All right, based on what I've heard, I think the recommendation of fines and costs is appropriate. Mr. Sherwood, obviously, there's a number of ways that the court can punish wrongful conduct. One of those ways is through incarceration. Another way, though, is through financial penalties, which sometimes can be just as punitive as a jail sentence. And in this case, based on what the lawyers have had to say about this incident, while your actions certainly exhibited poor judgment under the circumstances, which I'm sure wasn't helped if you had been drinking at the time, I don't find that the circumstances call for a jail sentence. So I agree again with the imposition of fines and costs as a way to impose a penalty here. So the court is, because this is reduced to a misdemeanor for the plea agreement, the court is going to assess a crime victim's assessment of $70, a state cost of $50. Are you appointed in this case, Mr. Seeger?
I was here.
Court costs of $325, attorney fees of $350, and a $100 fine. You do have the ability to seek an appeal of the sentence, Mr. Sherwood. If you wanted to do that, you would need to file that paperwork within the next 21 days. If you have more questions about that part of it, you could ask Mr. Seeger and he'd be happy to explain that process to you. Otherwise, I just need you, after leaving court today, to go next door to the clerk's office and set up a plan for paying those fines and costs. Do you have any questions at all?
No, Your Honor.
Okay. Thank you. That's all for today. Good luck going forward.
Thank you, sir. I'll follow right through.
And the last file that I have is Mr. Consdorf. He's lodged.
See at Wexford.
He last was at Wexford unless they brought him here today.
Okay. Do you know if we got any?
This is Mr. Consdorf here.
Okay. Oops, wrong one. Sorry, Ms. Wagner. I didn't mean to try to unmute you there. All right, are you Justin Consdorf?
Yes, I am.
All right, so we'll go on the record in People versus Consdorf. This is file number 265148. The record should reflect that Mr. Consdorf is present today by video from Wexford County. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of People, Your Honor.
Thomas Seeger agreeing with and on behalf of Mr. Consdorf.
Mr. Seeger, can you tell me the status of this file here today?
Your Honor, it's my understanding that the people have offered Mr. Consdorf an opportunity to plead to one count of assault with intent to do great bodily harm less than murder via strangulation. In exchange, all other counts will be dismissed. The most meaningful part of this plea agreement, Your Honor, is that by virtue of the plea, he would not be placed on the registry.
Mr. Ziegler, is that a correct statement? Plead guilty to count 2?
That's correct.
Your
All
Honor,
other counts dismissed?
Correct.
I neglected to mention, Your Honor, that it's my understanding that the people do not necessarily endorse, but will not object to, and will defer to the court relative to whether or not the court would grant him FIDA. But that would be a sentencing issue that the court would have to consider at a later date.
Okay, yeah, I'm certainly, given the allegations here, including the conduct that's going to be dismissed, I guess I'm going to need to take a close look at a PSI to understand the facts here before I make that determination on FIDA. So just for the record, I'm making no representations about whether the court would or wouldn't agree to that as part of the sentence in this case. Mr. Consdorf, have you been able to hear everything that we've said here so far?
Yes. Yes, Your Honor.
Have you had an adequate opportunity to discuss this plea agreement with your attorney?
Yes, Your Honor.
And did you want to go forward with that agreement here today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Consdorf, are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to count 2, which is assault to do with intent to do great bodily harm less than murder or by strangulation, that's a felony that carries with it a maximum possible penalty of up to 10 years and or a $5,000 fine?
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
You understand that by pleading guilty, you're going to be giving up and waiving all of those rights, including the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty to this crime because you are actually guilty?
Yes, Your Honor.
The information I have indicates that this happened back on December 20th of 2025. Is that the correct date?
Yes, Your Honor.
And on that date, were you present here in Kalkaska County?
Yes, Your Honor.
And on that date, did you commit an assault on an individual named Mackenzie Schmidt?
Yes, Your Honor.
All right, and as part of that assault, did you put your hands around her neck or his neck?
Yes, Your Honor.
All right, and was that part of an intent on your part to either suffocate or strangle that individual?
Yes, Your Honor.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
I'm satisfied.
Mr. Seeger?
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Mr. Constorf, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, somebody from the probation department is going to be in touch with you to do a pre-sentence investigation. They'll prepare a report that you'll have an opportunity to go through with your attorney prior to the sentencing hearing. Mr. Seeger, anything further here today?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
All right, thank you, Mr. Constorf. That's all for this hearing today, and the court's going to disconnect at this time. Gonna take a short recess before our next case, just about 5 minutes, and then we'll be back on the record. Chisholm, if you can go right to the podium there for me, please. Okay. On the record and People versus Jasmine Chisholm, this is file number 255123. The record should reflect that Ms. Chisholm's present here in the courtroom today. You have counsel put your appearances on.
Ryan Ziegler, on behalf of the people.
Kyle Travis on behalf of Mr. Chisholm.
All right, this is the date and time set for sentencing in this matter. Ms. Chisholm, did you have an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, I did.
And Mr. Travis, are there any additions, deletions, or corrections to that report? I did get the memo regarding the HIDA.
Thank you, Aaron. I guess two issues. One, in the memo regarding HIDA, I misstated the recommendation. It is not a recommendation for credit for time served at 99 days. It is actually, I believe, my interpretation is a recommendation for 6 months in jail. Also, Ms. Chisholm did note on under family, it lists her father, Johnny Chisholm. It looks 6395 Cram Road. That is actually apparently her grandfather's address, who is a senior of Mr. Chisholm, so not an uncommon that they get confused. And I don't know if it's super essential to the report, but it's her grandfather's address, not her father's address.
Okay, so we'll strike the address then. Any other changes?
No, Your Honor.
Okay. Any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today? No. Okay. I should note that there was a victim's impact statement that was attached to the PSI. Did have an opportunity to review that as well. Anything on behalf of the people for allocution?
Your Honor, I think the recommendation in this matter is appropriate. I'd ask the court to adopt it. The recommendation calls for 6 months of jail followed by 2 years of probation. I think the jail recommendation is appropriate primarily because of the nature of the offense. This was a serious crime where the victim was stabbed in the back with a knife. He was hospitalized for several days as a result of that injury. To top that off, when Ms. Chisholm was arrested, she bit one of the troopers involved, causing him a minor injury to his finger as well. Jail punishment is clearly warranted on those facts alone. I also think the term of probation is warranted. I'd ask the court to adopt that as well. It's clear the defendant is a young person. She has the time and the ability to reform, and she's dealing with some combination of either alcohol abuse and or mental health issues. An extended monitoring by the court is appropriate, both to provide her resources to deal with those issues and to ensure she does not engage in similar behavior like this in the future. So I think the recommendation contained in the report makes perfect sense to me, Your Honor. I'd ask the court to adopt it.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, a couple things. As noted, and I think Your Honor took this as a no contest plea, Ms. Chisholm was rather intoxicated when this happened. She has expressed a desire to attend rehab. If Your Honor were to follow the recommendation, I would ask the court to consider allowing her to the opportunity, if she could get in, to do a day-for-day credit towards the end of that sentence to go to a rehab. Albeit not an inappropriate recommendation, the recommendation for basically a guidelines max and probation, I would say is not the most common, totally legally permissible, obviously, but so if the court is inclined to place her on probation, I would come back to my memo relative to the HIDA. I don't really see a harm in that, and it would be a great benefit to Ms. Chisholm and potentially a benefit to the community. I do think, and she knows she has a problem with alcohol, which is unfortunate. She had come to the court at 19 today. She was actually 18 when this occurred. She had her 19th birthday while incarcerated. She has been incarcerated for a little over 3 months already, so there has been a jail term. She's never been incarcerated before, so all of this is having an effect on her. I know she's quite remorseful about what happened. from what I've learned about her living situation and that situation, it was not good to say the least. It's noted that she's not employed and wasn't working. That's one thing I've talked with her about, that I'm quite hopeful that she comes out the other side of this, potentially able to support herself and not feeling as though she needs to depend or get involved with, you know, older men who feed her liquor. There's a lot of potential upside here for Miss Chisholm. She's young. She has no criminal history other than this. She can move forward and have a wonderful life, or she can go further down the path of substance abuse problems and destructive relationships. She's knows that. She's, you know, remorseful about what happened. She believes that had she not been intoxicated, she would not have responded to this situation that way. It's probably completely accurate. So I'm quite hopeful that she can turn a very bad situation for a young person and for Mr. Yoder. Obviously, this was, nobody deserves to be stabbed, no matter the circumstances, really. And it was quite serious. And she's quite remorseful about that. But I'm hopeful she can come out of this in a better situation as a young person, because she is quite young. Thank you, Your Honor.
All right, thank you. Ms. Chisholm, anything that you wanted to say today?
Yes, please, and thank you. I would like to apologize to the courts of my irresponsible actions that I have done. I know that I am 18 years old and I'm still an adult. I should have told myself no to the alcohol, and because I fell into the addiction, I have harmed 2 innocent people, and I'm hoping that the officer is doing well and did not get sick or any other harm to his hand. And I hope that Mr. Yoder, my former partner, is breathing and he's doing well with his health. I really am sorry.
So I read through the report. I'm familiar with what happened in this case. Also, just your background, your circumstances and so forth, based on the information in that report, as well as what the lawyers have had to say and what you've had to say. I will say you appear to be genuinely remorseful to me here, and that's a good thing. That means that you recognize this is not conduct that's acceptable. In terms of an appropriate sentence here, I think the court has to look at 2 things. Number one, the seriousness of the conduct that you engaged in. However it happened, being intoxicated to the point where you don't really remember what happened and probably didn't have control over your actions, conscious control at least. The harm that was caused, I mean, we had an individual that was injured seriously enough that they had to stay in the hospital. And actions and an injury which could have been much more serious than they were. If you had hit, you know, an artery or a vein or something that where they couldn't stop the bleeding, this person could have died from this injury. So incredibly serious conduct, and concerning conduct. But I think I also have to look at the rehabilitation aspect of this, because you are now 19. You have very little life experience at this point, and you've got a lot to go ahead of you. And so I think given your lack of having been in any kind of trouble before this, gives the court some reason to believe that if you can get some help and get some treatment through a course of probation, that you could move forward from this and be a productive member of our community, not be somebody who's causing trouble, but somebody who is being a positive influence in the community. So I think a sentence that combines those 2 things is called for here. I think given the seriousness of your conduct towards both of the victims in this case, I think calls for a 6-month jail sentence, I think is absolutely reasonable and fair. I think a longer sentence probably could be justified given the seriousness of your conduct and the potential harm that could have resulted and the harm that did result. I also think that probation is appropriate to monitor you, to make sure you get yourself on the right track, and that you stay on the right track. I think allowing that probation to the extent you're eligible to be pursuant to HIDA, I think is fair. It gives you an opportunity as somebody who's 19 to have this come off your public record if you are able to be successful on probation. And there's really no risk to the court or the community in giving you that opportunity, because if you don't follow through with it, you'll lose that HIDA status and this will remain on your record. If you do, it'll give you an opportunity to move forward, have employment and other opportunities, and not have that hampered. So I think that sentence provides an appropriate degree of punishment given your age and the circumstances, but also allows for the rehabilitative aspect of this. So the court is going to sentence you to 6 months in the Kalkaska County Jail. You do have credit for 99 days served. The court, and this is as to both counts, the court is going to place you on probation for a period of 2 years pursuant to HIDA. The court is going to adopt as the terms and conditions of your probation all of the terms and conditions listed in the report. That includes completing any outpatient or residential substance abuse treatment once you're released from jail, completing any mental health or domestic violence intervention or other treatment or counseling that's recommended to you, not having verbal, written, electronic, or physical contact with Daniel Yoder, either directly or through another person, or be within 500 feet of his residence, school, or place of employment, not using or possessing any objects as weapons, not engaging in any assaultive, abusive, or threatening or intimidating behavior, not using or possessing any alcoholic beverages or other intoxicants, along with the other provisions which your agent is going to go through with you. The court is going to order a crime victim's assessment of $130, a supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a state cost of $118. You do have the ability to seek an appeal of the sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with that appeal. And Mr. Travis, if you can have Ms. Chisholm acknowledge receiving those appellate rights, please. Good luck to you going forward, Mr. Trump.
Thank you, Your Honor.
Versus Larry Flowers, case number 255115. Record should reflect Mr. Flowers is present here in the courtroom today. I could have counsel put your appearances on.
Brian Ziegler on behalf of the Your Honor.
Kyle Travis on behalf of Mr. Flowers.
This is the date and time set for sentencing in this matter. Mr. Flowers, have you had an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yeah, yes, I'm sorry.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Not anymore, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Right. Mr. Ziegler, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, this was a plea that was reached between the parties, as sort of a pseudo 7411 agreement. It was amusing to myself and Mr. Travis that even though we believe that he has a conviction for possession of marijuana that was expunged, it doesn't appear in the PSI, but we do believe he has that conviction, and we do believe it does make him ineligible for 7411. But I think other than that, Mr. Flowers is very likely to do well on probation. He has no other criminal history that we're aware of. I think that makes him a good candidate to successfully complete the terms of his delay, and I hope he takes full advantage of those terms.
Mr. Travis?
Thank you, Your Honor. Yes, I think the PSI very much makes the argument that the delay that Mr. Ziegler offered and that Your Honor accepted it is appropriate in this case. Mr. Flowers has had some troubles as of late, as indicated in the report. He's moving forward with that. Got to take more notes, got to plan the day out better. But he's doing well. I think he will do well in this probation. He's taking it seriously. He's motivated to do well. So we would ask Your Honor to follow the recommendation.
Flowers, anything you wanted to say?
I'd just like to acknowledge that I know what I did was wrong. I had up my butt, for lack of a better term. I would also like to thank the prosecution for going out, finding a better sentence or sentencing for me, since I did not qualify for the 7411. I appreciate that. I just want to move forward from this and everybody's here.
All right. Well, I hope that's the way it goes. That's what we're all hoping, I think. And you're gonna have an opportunity to do that through this delay of sentence. And I think under the circumstances here, the lawyers have indicated the reasons why, and I agree that it is an appropriate resolution. It's going to give you an opportunity to avoid any kind of jail time in this case. And if you're not successful, I'm sure Mr. Travis has gone through the guidelines with you. There's potential of up to 6 months in jail. So I hope that provides an additional motivation to you to comply. So the court is going to follow the recommendation in the agreement and put you on a delay of sentence for 12 months. The court is going to adopt as the conditions of that delay all the terms and conditions listed in the report, and that includes not using or possessing any controlled substances unless they're prescribed to you by a physician, as well as all the other terms and conditions which your agent will go through with you. In order to get the benefit of the delay here, you'll need to, before it's over, you'll need to pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost, along with a fee of $30 per month during the delay for supervision. The court isn't going to address any jail time or jail credit at this point, given that this is a delay. So Mr. Flowers, it's very important that you go through this with your agent. Ms. Wagner, I know Mr. McFeld is the one who did the PSI. Are you going to be the supervising agent here?
Yes, if he can come over to the office, I'll get him set up with reporting instructions. Thank you.
Okay, so just check in with Ms. Wagner before you leave here today. And, again, it's very important to stay in touch with her and make sure that you're complying with all the terms, okay?
Good.
Do you have any questions at all?
No, sir.
Okay, good luck going forward. Thank you.
Thank you.
Thank you, Your Honor.
Mr. Williams, were you ready with Ms. Green's case?
I am, Your Honor.
Okay. People versus Heather Green, file number 255053. The record should reflect Ms. Green's present here in the courtroom today. If counsel can take your
Jesse was time this week.
This is the date and time set for sentencing in this matter. Ms. Green, have you had an adequate opportunity to go through the report with Mr. Williams? Mr. Williams, are there any additions, deletions, or corrections?
No, Your Honor.
And are there, this is the one you're looking at, no guidelines. Mr. Ziegler, do the people have any additions, deletions, or corrections?
Yes, Your Honor, on page 2 and page 4 in the recommendation narratives regarding the restitution. At both those places, it says that the restitution is payable to the state of Michigan. It's somewhat of a moot point because the restitution has been paid in advance, but that's not accurate. $15,808.50 of that was payable to the Social Security Administration at the federal level, and the remaining $4,899 was payable to the state of Michigan. So it was payable to the state of Michigan and the Social Security Administration.
All right, thank you. We'll make that correction. Any other corrections?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I think the recommendation in this case of a brief, straight jail sentence is probably a fair and appropriate outcome. Ms. Green claimed benefits she was not entitled to from multiple different government agencies, state and federal, to the tune of over $20,000. This was not an isolated incident or an accident. She repeatedly told the Department of Health and Human Services that her daughter was residing with her when she knew that her daughter was in an alternate placement, and she was provided very little in terms of her actual care. Later, she applied for Social Security benefits and for RSDI benefits on her daughter's behalf. She forged her daughter's signature, and she did not provide any of those benefits to her daughter. To her credit, however, she's made full restitution to the government for these overpayments. I did receive checks from the defense about 3 weeks ago, and I've dispersed those to the relevant agencies. So all of the restitution is paid in full at this time. I don't believe probation is necessary or appropriate under these circumstances. There's no need to monitor her payments, and there's very little to be gained from her regularly checking in with the state. She's either learned a lesson from all of this and she's not going to do it again, or she has not, and probation's unlikely to change that either way. However, I do think some punishment is warranted to let others in the community know that you can't simply defraud the government and then skate entirely if you pay that money back later. I'm sure this has been a long and difficult process for Ms. Green, but I think a jail sentence is warranted in this case, Your Honor, if for no other reason than simply to deter other members in the community who would consider engaging in similar actions. The fraud at issue was significant, but she has no prior history and she's made full restitution. I think a sentence of 30 days is a reasonable balance given all of that, Your Honor. So that's what I would ask the court to impose.
Thank you, Mr. Williams.
Your Honor, may I approach? I just have 2 short letters that were
Yes.
provided today. I did present them.
Thank you. Did you want these back? Mr.
Sure.
Williams and Tenney? And then anything for allocation.
Thank you. All right. I mean, I don't know about people defrauding the government and skating. It's a wild world we live in these days, but the family's always complicated, always layered. She's taking care of one family member. She's got a disabled other family member. She paid everything back in full. I don't believe that putting her in jail, like the recommendation, I believe was 9 days, but incarcerating her certainly is not going to deter the next person who is financially strapped and juggling different family members with different problems. Not as if she was out vacationing and living some luxurious life at the government's expense, flying around on airplanes and other things. I agree that probation doesn't make sense. She comes before the court with no record whatsoever. She's a primary care provider for her mother, and she's making ends meet in life. I would just ask the court to censor fines and costs at this time. I really don't believe that incarcerating her will deter anyone in this similar circumstance, nor do I believe it serves any purpose to her. I mean, this case has been going on for some time. We've adjourned it so she can make this money back, and now just to put her in jail, that doesn't make sense. If we look at how a felony is treated, just statutorily, she's in a presumptive no jail sanction. And she's, it's a misdemeanor, but 0 to 18 months is presumed no jail. So just to incarcerate her, just to punish her, I really don't see how that's a value to anyone at this point. So I would ask you to censor fines and costs, Your Honor.
All right, thank you, Ms. Green. Anything that you wanted to say? Okay. All right, Ms. Green, I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your circumstances and your background. I take all of that into consideration along with what the lawyers had to say here today. And looking at these circumstances as a whole, I think sometimes people fall into this trap where they see a way that they might be able to get some extra funds. And I think a lot of people are legitimately in need of money. And I think they tend to engage in these kind of crimes when they don't think that this is going to get found out. In other words, that the bureaucracy is just so big with all the cogs in the wheels that it's just not something that's going to be discovered. And so I think that's an added temptation between the needs that they may have and the thought that this is money that they could get a hold of without any repercussions. And from what I read, I think that's what happened in this case. It may not be, but from what I read, that's what it looks like to me. You don't have any prior history. You did make efforts to repay all of the money. I think those are both factors that work in your favor. Obviously, your conduct in this case is something that works against you and that the court finds is something that requires the imposition of some type of punishment. In this case, and in every case, the court has at its discretion the ability to impose jail time as a punishment. Financial punishments are also an option that the court has to employ when it finds that jail time isn't appropriate. In this particular case, the recommendation is for 10 days. The prosecutor is asking the court to impose 30 days. Your attorney is asking the court not to impose any jail time. And in my view, I think a short jail sentence is appropriate in this case. For somebody that's never been to jail before, which I don't think you have based on the information here, it can be a very significant experience that I think would impress upon you that this is not appropriate conduct. And I don't think it needs to be a 30-day jail sentence. I think for somebody that hasn't been to jail before, a shorter sentence can drive that message home. And I think it is something that's necessary in this case, given the amount of money and the circumstances that there be this punishment. I do think it does serve as a deterrent if people know that it isn't a situation where you just pay back the money and everybody goes on their way. So for those reasons, I do find that a jail sentence is appropriate. The court is going to sentence you to 14 days in the Kalkaska County Jail. You do have credit for 1 day served. The court is going to order restitution, but that's already been satisfied. The court is going to order a crime victims assessment of $75, court costs of $325, a DNA testing fee of $60, and a $53 state cost. You do have the ability to seek an appeal of this sentence. If you wanted to appeal this sentence, you would need to file for that appeal within the next 21 days. If you have additional questions about that, then you could ask Mr. Williams. I'm sure he would be able to explain that process to you. Otherwise, you are going to be remanded to the custody of the county at this time. Mr. Ziegler, anything further on this file today?
There you go.
Mr. Williams?
No, sir.
Okay, thank you. That's all for this. People versus Lambert, file number 255020.
That's her sister. I'm a brother-in-law.
You know if Ms. Gittleman was appearing by video?
I assume so, Your Honor, but I don't know.
Yeah, Mr. Lambert connected.
We are a little early, Your Honor, by my reckoning.
Behind all morning. Mr. Lambert, your hearing is set to start at 11. We're about 10 minutes out from that. Your attorney has not connected yet, so we're going to take a short recess. I'm going to have you remain connected here. And then when we're ready to start with your hearing, we'll begin, okay? Oh, wait a second, your attorney just connected. 1 minute. Let's get, you can hear me. We're ready to begin the hearing. Oh, there you are. Okay. Can you unmute for me, please?
Oh, there we go. Okay.
All right. We're a little bit early. Are you ready to proceed with Mr. Lambert's hearing?
I am, Judge. Thank you.
Okay, we'll go on the record and People versus Lambert, file number 255020. The record should reflect Mr. Lambert's appearing today by Zoom from Department of Corrections. If I can have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Good morning, Your Honor. Tracy Gittleman for Mr. Lambert.
All right, this is set for a hearing today on defendant's motion to withdraw the plea or for a Ginther hearing. I did have an opportunity to review the motion and brief submitted by the defendant. Mr. Ziegler, I did get your reply. I had a chance to review that as well. For purposes of today's hearing, in terms of oral argument, Ms. Gittleman, anything that you wanted to add?
Really nothing to add, Your Honor. I mean, I know I wrote quite a lengthy brief and attached Mr. Lambert's affidavit as an offer of proof that his counsel he's claiming is ineffective and his plea was not knowing, voluntary, and intelligent because of the defenses of entrapment and search and seizure. I did lay out how the pre-sentence report documents and supports defenses for entrapment and issues of search and seizure. These are waived with a plea. However, if there is ineffective assistance of counsel, Your Honor would rule based on that then the plea would be defective because it would not be intelligent and knowing. I don't have anything to add to my brief other than what I've already written, so I don't have anything else other than that, Your Honor. Thank you.
Thank you, Mr. Ziegler.
Your Honor, I think my brief adequately explains why I don't believe there was any ineffective assistance of counsel in this case. I think the burden is on the defense, at least to make a prima facie showing that there was ineffective assistance. I don't think that burden has been met. I don't think there's a need for a Ginther hearing in this case. I think the facts are plain. So I would simply rely on my brief questions.
I don't. Ms. Gittleman, anything that you wanted to say in response to the prosecutor's argument here today?
The only thing that I would respond to is that we are making the offer of proof with Mr. Lambert's affidavit regarding that, and that triggers at the very least a Ginther hearing to explore the issues and whether they were asserted or not, and explained to my client as to whether they could be asserted, the risks of asserting or not asserting those, the fact that failing to assert those waives his rights to do so upon a taking of a plea of guilty or no contest, in this case, guilty. Because of that, we would request any alternative of Ginther hearing if Your Honor will not be withdrawing the plea. Thank you, Judge.
All right, thank you. Again, I did have a chance to review the motions. I also had a chance to review the file generally prior to the hearing today, just to refamiliarize myself with Mr. Lambert's case and the circumstances that were present. during the course of this incident that brought him before the court. And looking at, so I feel comfortable in ruling on the record here today, given that the arguments of counsel have been consistent with what was presented to the court prior to this in writing. First of all, with regard to ineffective assistance, the court has to find that the performance of trial counsel fell below a reasonable or objective standard of reasonableness, and that it resulted in some type of prejudice to the defendant. In other words, the outcome of the case would have been different had counsel performed differently. Whether or not there has been ineffective assistance is something that is on the burden of the defendant to make a showing of, and that burden remains with the defendant in terms of providing a basis for a Ginther hearing. A Ginther hearing should be ordered and is within the discretion of the court, but should be ordered when the court finds that further factual development is necessary in order to determine whether or not trial counsel's performance fell below that objective standard of reasonableness. Generally, matters of trial strategy are not second guessed by courts. Again, as long as that strategy was within a standard of reasonableness. In this case, there are essentially three bases why the defendant argues that his counsel's advice prior to the plea and performance prior to the plea was deficient. Number one, the argument is that defense counsel should have raised an entrapment defense. In reviewing everything, all the documentary evidence that the court had in this case, including the PSI and of course Mr. Lambert's affidavit, the court finds that there is not sufficient evidence that law enforcement was using Mr. Wood to get to Mr. Lambert. In other words, that Mr. Lambert was somehow induced into committing this crime by the actions of law enforcement through Mr. Wood. I just don't find that there's any factual basis to support that. Certainly there wouldn't have been any available to trial counsel prior to the plea. And so I don't find that it was below an objective standard of reasonableness for trial counsel to conclude, to the extent that an entrapment defense was considered, to conclude that it would have been futile or at least not warranted or likely to succeed. And I think one thing that has to be considered is at the time these things are being evaluated by trial counsel, they're in the midst of plea negotiations. And if trial counsel has a potential issue that they could raise, but it could result in a withdrawal of a plea agreement or a worse plea agreement, then the trial counsel has to weigh the likelihood of success of that type of motion versus the harm that it would do to the defendant's case. And so again, I think that's within the ambit of trial strategy by the trial attorney. And again, given the facts here, I think it's an entrapment defense is unlikely enough to succeed that it certainly was within an appropriate standard of reasonableness for trial counsel to conclude that from a strategic standpoint, raising that defense either was going to be unsuccessful or could result in a withdrawal of a more favorable plea agreement, such that raising what was likely to be an unsuccessful defense would only further hamper the defendant's case. Likewise, with the argument that the traffic stop of Mr. Lambert was pretextual, again, I don't find the facts of this case to support a strategy by trial counsel of filing a motion or raising that as an issue prior to the plea for the same reasons that entrapment wasn't. I just think, given the state of the law and given the facts surrounding Mr. Lambert's traffic stop, that any argument that it was pretextual or not supported by probable or reasonable cause was very likely to be unsuccessful. Therefore, I think it's reasonable for trial counsel to conclude raising that issue prior to the plea would do more harm than good as a matter of strategy. So for all those reasons, the court finds that number one, a Ginther hearing isn't necessary in the court's discretion to develop any facts in this case. I think they're apparent enough in the circumstances. And that there isn't a basis to allow the defendant to withdraw his plea based on ineffective assistance of counsel. So for those reasons, the court will deny the motion. Ms. Gittleman, the court would request that you prepare an order reflecting the ruling of the court and submit that either under the secondary rule or with a stipulation from the prosecutor as to form.
I will, Judge. Thank you.
All right, thank you. That concludes this hearing today, and the court's going to disconnect at this time.
Thank you, Judge. Take care.
Thank you. Next hearing is set for 11:15. We'll take a short recess until that time.
Your Honor, I do have two letters, a letter from Mr. Hyatt's significant other and his mother that Mr. Ziegler didn't get a chance to look at. If I can have this report.
Yes, please. Did you want these attached to the PSI?
Thank you, Your Honor. Yes.
Okay. So we'll go on the record in People versus Hyatt, file number 255139. The record should reflect Mr. Hyatt present here in the courtroom today. This is the date and time set for sentencing. And pardon me, Mr. Hyatt, did you have a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes.
Mr. Travis, are there any additions, deletions, or corrections?
If not, that I'm aware of, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, people have any additions, deletions, or corrections?
Yes, Your Honor. Under the description of offense, second page of the description of offense, about the middle of the page, there's a paragraph that starts with the male driver was subsequently identified. In that paragraph, there's a parenthetical statement that says bases for OV14 as Hyatt was driving in a multiple offender situation. I would ask the court to strike that. OV14 was not scored in this case, and I think correctly so. It was not scored because the passenger in the vehicle was not an offender. So I would just ask the court to strike that reference to a basis for scoring OV14.
Any objection?
No objection, Your Honor.
Okay, we'll make that correction. Any other changes?
No, Your Honor.
Okay. Anything on behalf of people for allocution today?
Your Honor, I think the recommendation in the report for prison is clearly appropriate in this case. Mr. Hyatt was on parole and he was on bond for another felony matter out of Antrim County when state police attempted to stop his vehicle. He fled from Trooper Tabatas. Another officer, Deputy Ray Ferrier, also attempted to stop his vehicle and he again fled from that officer, ultimately crashed his vehicle into a tree. Luckily, despite fleeing from multiple officers and crashing his car, no one was seriously injured as a result of his conduct, but they very well could have been. His guidelines are 10 to 23, which in my mind strongly recommends a prison sentence. And the fact that he was already on parole and committing multiple felony offenses while on parole only underscores that, Your Honor. I would ask the court to sentence the defendant to 18 months prison consecutive to any parole violation.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, as you've seen, Mr. Hyatt's doesn't have the best record. It's actually starts with juvenile issues, and he has been to prison before. He is on parole. We understand that the conduct is not encouraging. Mr. Hyatt did, take his offer, plead guilty, and has acknowledged his behavior was inappropriate. As noted in the PSI, he's under sentence out of Antrim County for a narcotics case. I do think Mr. Hyatt's got a raft of problems that started in his youth. Clearly, he's been, remorseful, appropriate, and not denying reality this whole time, which I think is nice to see from someone with his history. Truthfully, we initially had planned to ask Your Honor to give him a county time sanction. I realize it is at the bottom of the guidelines, but it is within Your Honor's purview. In talking more about that and realizing his status, I don't know, and I know this is not necessarily Your Honor's main focus is what's best for Mr. Hyatt, but not knowing what MDOC is going to do, I don't know that would necessarily not actually cause more problems for Mr. Hyatt. I'm really not sure. If MDOC wants him to go to prison, they have the chance to do that. And if Your Honor doesn't send him they might well do that. As I was telling Mr. Hyatt, by no means is it this is what happens, but oftentimes speaking with clients and after the fact, if they're satisfied with what comes out of the trial court, they'll just, stack the tails and kind of leave it at that. So I know Mr. Hyatt wants to move forward from these things and try and be productive and get back to his family. He's got letters of support and other support here in the courtroom. But I generally don't know what would be best for Mr. Hyatt. I know that's not the court's primary concern. Would that be a county time sanction or a prison term? So I can't tell him because the reason I talk about all this is there's still a large unknown of what MDOC is going to do. That hasn't happened yet. So we would ask Your Honor to give what you feel is an appropriate sentence. Thank you.
Thank you. Mr. Hyatt, anything you wanted to say today?
Yeah. Past juvenile records messed up. Adult record messing up. I should have stopped when they flicked me, but I didn't. Seen them cowboys come back on, I wasn't trying to go back because I was on parole from Antrim County. And all I asked, I got family out there that's not doing good. All I asked for maybe a little bit of lenient on time.
All right, well, I read through the report, so I'm familiar with the circumstances of what happened here and your actions that bring you before the court today. I'm also familiar with you, generally your background and your circumstances based on the information in that report. So I take all of that into consideration. I did get the 2 letters that I read here just shortly before the hearing started. And also what both the lawyers had to say and yourself. I might try to take all of those things into consideration in determining what is an appropriate sentence. I think to the extent you have, family here that aren't doing well, you've had an opportunity to remain out of jail or prison through your parole, and this incident took place, and you made the decisions that you made. And so, while I certainly sympathize with them and understand what they would like to see, ultimately it's your decisions that put you where you're at. And the further you go down this road, the less opportunities there are going to be for you to remain local and to get community sanctions. And in this case, your actions here put the officers in danger, they put yourself in danger, put your passenger in danger, they put other innocent people who had nothing to do with this, who were out on the road at this time in danger. And that's something that I think the court has to take very seriously. Because it's clear to me that regardless of what your family's needs are, that you're making decisions about what you think is going to be best for you in that moment, regardless of whatever harm or danger it puts other people in. And that includes later on down the line. And so to me, that tells me that you're in a position where the court has to be concerned about public safety, because you're going to put what you think is going to be expedient for you in that moment ahead of other people's safety. Given your past history, given your status on parole during this incident, where, had you just pulled over, maybe you get a civil infraction for no license plate or something like that. You turn this into something that it really didn't need to be, in addition to the danger that you put everybody else in. So for those reasons, the court finds that a sentence at the top of the guidelines is reasonable, it's appropriate, it addresses your conduct in this case and your past history. The court is going to sentence you to the Department of Corrections for a period of 23 months to 5 years. Because of your parole status, you don't have any credit. The court is required to make the sentence in this case consecutive to any parole sanction. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and we're going to provide you with some papers that explain to you what your rights are, as well as how to request a court-appointed attorney to help you with any appeal. Mr. Travis, if you can just let me know once Mr. Hyatt has acknowledged receipt of those vote rates. I have already made it to custody of the state at this time. Do we have Miss Massey present?
We do, she's just outside, I think.
If I could have Miss Massey come up to the podium, please. People versus Massey, file number 255145. Record should reflect Miss Massey is present here in the courtroom today. If I could have counsel.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mrs. Massey.
Mr. Travis, can you tell me the status of this file?
Your Honor, we did waive the preliminary exam based on an offer to resolve the matter under 7411. I've had not a lot of conversations with Ms. Massey individually and speaking with some family members yesterday, actually, started to have some concerns about how she's doing mentally. Just to be frank with the court, was considering requesting competency. I've spoken to her today. I'm not making that request right now, but I would ask for the adjournment for her and I to talk some more, because I'd like to get a more informed handle on whether we want to do that.
Mr. Ziegler?
I have no objection.
All right, I think that's a fair request. This case was found over not too long ago. The only thing, I will set it for another status conference in 30 days. The only thing, Mr. Travis, that I would request is if you have your discussions with Ms. Massey, you make the determination that you need to submit this for a competency review, that you don't wait for that hearing. We can get that ball rolling sooner. And I think the sooner we do that, the better. So, and if you determine that that's not an issue, then we're fine going forward at that next status conference.
Thank you.
Do you have any questions about that?
No questions.
Okay, Mr. Ziegler?
Yeah.
So Ms. Massey, you just need to make sure you stay in touch with your attorney and have some discussions with him, okay? Do you have any questions about that? All right, thank you.
Thank you. Thank you.
That's it, Mr. Ziegler?
That's all I have now.
All right, ma'am, are you Ms. Precord Melancone? And sir, are you Mr. Melancone?
Yes, sir.
Sir, you can come up to that table. Ma'am, you can come up to that table. Please be seated. Record today, we actually have two cases with these parties. One's later this afternoon, but we can take care of them both here this morning. So you don't have to come back. We have file number 2615004, which is personal protection action. And then we have 2514949, which is a divorce action. The record should reflect both parties are present here in the courtroom today. And with regard to the personal protection order, Mr. Was it Melancone or Melancon?
Melanson.
Melanson. Wasn't even close. All right.
I'm used to it.
This is your motion today. You're asking the court to terminate the personal protection order. Is that correct?
Correct.
Okay. And so that was entered by this court back in January. Ms. Precourt, are you asking that order to remain in place?
Yes, I am.
Okay. So what we're going to do for purposes of that part of things today, and we'll talk about the divorce file in a little bit. But what we're going to do for purposes of the personal protection order, Ms. Precourt, is it okay if I refer to you as Ms. Precourt?
Yes.
Okay. Because you obtained that order without the court getting Mr. Melancone's side of things, then the burden is on you to go forward today and to show the court why you believe this order needs to stay in place. So I'm going to be placing you under oath, and you can give me your testimony as to why you think it needs to stay in place. You need to show the court by a preponderance of the evidence, or that's just tipping the scales one way or the other, 51% to 49%. That's a preponderance of the evidence standard. You have to show the court by that preponderance of the evidence that there are circumstances that require this order to remain in place.
Okay.
So because she has the burden of proof, then she will give her testimony first. Then, sir, I'll put you under oath. You'll have an opportunity to tell me what you think is important. I did read through your motion, so I'm familiar with the information that you put in there, just to let you know. And Ms. Precourt, of course, I read through again your petition and the circumstances that you cited for asking the order and for the order in the first place. So after you give your testimony, sir, because Ms. Precourt has the burden here, she'll have an opportunity to respond to anything that you have to say, and then the court will make its ruling as to whether the order stays in place, whether it should be modified in some way, or whether it should be terminated altogether. So we're recording this in case we need to make a transcript later, so it's important that we don't talk over each other. I'll try not to interrupt either of you when you're telling me, giving me your testimony. I may stop you if I feel you're going into an area that's not relevant or not important to my decision. I may stop you and try to redirect you, but otherwise I'll give you both a reasonable opportunity to tell me what you think I need to know. I'll just ask that you don't interrupt me either. Any comments that you have should be directed towards me here at the bench. Please don't address each other across the aisleway there at the tables. Ms. Precourt, do you have any questions at all?
No, I do not.
Sir, do you have any questions?
No, Your Honor.
Okay, so if you both would raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Do you?
Yes, Your Honor.
Thank you. You can lower your hand. Okay, so Ms. Precourt, can you tell me why you believe this order needs to remain in place?
I had given a reason listed attached with a personal protection order. Initially, Rob and I, we've been together for over 11 years. I had filed for divorce last fall. At the time when I filed for divorce, we were still living together. We kind of had a mutual understanding that we would respect each other's space. I moved upstairs, he stayed downstairs. We both work nights, we work a lot of hours. So it was kind of to and from, going, we would kind of run into each other and talk a little bit and stuff. At the initial time of divorce, I just pretty much said, you have your stuff, I have my stuff, in reference to bills, which I don't necessarily need to get into that. We had an agreement. Moving forward, he was starting to have some issues with accepting the divorce, wanting to talk. He was openly expressive about having some mental health issues. And, I just kept saying, look, I'm sorry, but this is kind of what's needed. By all means, go on, do what you need to do. And anyways, as it progressed, the conversations and whatnot progressed. He had tried contacting me one night. I was unavailable, did not take his phone call. He has left a text message, and there's also audio recordings from voicemail that he had left. And it had stated on here, and I also have a photo of what he had said, that he almost killed himself, that he was on his knees crying to let it all end. that he'd never been so close. He wished he had the strength to do it and that life would be easier with everyone if he wasn't around. Amongst me missing, I didn't go through the house every day to notice things that may have been there, may have came up missing, but on the 14th, I had came home from working an overnight shift and looked, and the firearms that we had in the homes, there were 5 were gone. I had reached out to him, asking him where they were. He wouldn't give me the information other than that they were his guns and I didn't need to worry about it. Amongst the conversations, messages and whatnot that he had left for me, he had made remarks to my family members also, stating that he was wanting to, in ways, roundabout ways, end his life. That life would be better without him. So moving forward, there came a time when he had came to the house and it resulted from his cell phone being shut off. He had, I had called, asked him when he'd be able to pay the bill. He started getting kind of aggressive with me. I hung up the phone and in turn, he ended up leaving a voicemail message, which I have a recording of. And then I was sitting at the house on the phone. He came into the house starting screaming at me. I kept on asking him to please leave, please stop, please leave, please leave. He wouldn't, he continued to verbally attack me in an aggressive manner. I ended up calling 911 and I set the phone down. After he said what he felt he needed to say, he turned around and left. I picked up the phone and talked to dispatch. They asked me if I was okay. I told them yes, I was. They asked me if he had left. I said yes. They told me that there were officers en route and I told them it wasn't necessary. I just needed them on the phone in the event something kind of gotten out of hand. I asked them to keep the recording in the event I needed it for later. They still sent an officer out. The officer spoke with me, told me if I needed anything else to get a hold of them. The next day I filed the PPO order. I filed the PPO order based upon the fact that I understand said circumstances of divorce can leave people in mental turmoil. I understand the long, lengthy history of PTSD, given his upbringing, his background, his work career. I understand all of that. What I will say is that for me, this has been very traumatizing, him coming into my home not once, but twice. Since the PPO order was filed, when I initially took it over to the sheriff's department, the sergeant that was on duty told me that from the minute the PPO order was signed, that it was valid. And I said, okay, well, what if I have a hard time having him served? And he's like, even if he were to call you, you can call us and he would have to answer to the court for that. So in a sense, I felt kind of rest assured that even though there was a personal protection order, that I was somewhat protected. Moving forward, a few days ago, I was at my home, working in my bathroom, heard the dogs barking, turn around, and my son told me that Rob was there. I went out of the bathroom into the living room, and I seen him standing there, and he said that he was there to get some of his belongings, and I said, you cannot be here. I'm like, this can be dealt with when the divorce comes, you need to leave. And I'm like, you have a personal protection order. He wasn't understanding of that, started getting slightly verbally aggressive with me, and I handed him the personal protection order papers and I said, please leave. He said, no, he wasn't leaving, that it was his fucking house and that he was going to get the stuff that he had, that he wanted to get out of the garage. I then called 911. I told them.
What day was that?
That was the 25th of January. I called 911. I told them that I needed an officer immediately and that I had a PPO order and that the person it was against was standing in my home. They asked again, is he in the home? I said, yes. They asked if I was in the home. I said, yes. And I said, please send someone. And I hung up the phone. The altercation continued where he was yelling and screaming at me, saying all sorts of horrible things to me. When he turned around and went to leave, I asked him if I could have my papers back. He had them. He said no. So as he went to move towards the door was open. And as he went to walk out, my couch is next to my door. I had kind of gotten on the couch and reached in front of him, touching the inside of my arm right here, touched the outside of his arm as I grabbed the papers. And I said, no, please leave. This resulted in him leaving. An officer ended up showing up asking me questions in reference to if I had assaulted him. I was kind of dumbfounded, honestly, because no, I did not assault him. There was a conversation between me and the officer, and at that time he told me that Rob had went to his son's residence just down the road and had called the police making a complaint that I assaulted him while he was at my home. Here nor there. All I want is protection. I want to know that my home is a safe home, not only for me, but for my son and his girlfriend that lived there. I feel at this time, and since all of this has went on, my house is not safe. I am tired of the verbal abuse that I'm taking by him being upset about the fact that we filed for divorce. I tried to limit my contact. I honestly prefer not to talk to him, not to look at him, not have anything more to deal with him. I'm trying to move on with my life. And at this point in time, knowing that he's openly admitted things in his paper, such as that he was in an extreme emotional state due to the initial impact that it had on him, stating that I was not caring for our animal that he took, stating that he has one gun that he's legally carried and 2 hunting long guns. I don't have the proof of the guns that he had. I do have boxes of the various types of ammunition, and I also have a box that has a serial number on it for a shotgun that was purchased. So I feel in ways he's not being truthful in reference to the weapons that he has. I wish him nothing but the best for his mental stability, and I hope that he continues to get the help that he needs. But he's clearly indicated more than once that he is mentally unstable in ways, and it's concerning to me.
Okay. You said that at the time that you got the PPO, you were still living in the same household? Or no?
To him, yes.
Well, I don't want to know what
Right.
everybody's impression was. I want to know who was actually.
No, he was
living.
not. I was living in the home.
All right. So, because you said at one point after you decided to get divorced that you both were living in the.
We were living in the same home, and then he turned around and one day didn't come back. So I'd have to go back through and look at the exact date, but he's been gone well over 30 days.
Just ballpark in relation to when you filed the PPO, how long had it been? prior to that?
A few weeks before that, yeah.
All right, and then, so I signed this PPO on January 8th, but he wasn't served until the 25th.
Correct.
Right, so, okay. Did you do anything during that time period to let him know that there was a?
I didn't have any contact with him whatsoever.
Right, but did you request the sheriff's department to?
Yes,
serve him?
yes, the papers were taken to Kalkaska County. And the kind of hiccup with that was that the only address I physically knew where he would be at was his work, which was in Wexford County. And that's why that address is listed on the PPO order that I filed.
Okay.
The sergeant told me in Kalkaska County, because I had given them the location of where his son lived. They said that they would try and serve it. And I said, okay, in reference to service, will I get notified? And they're like, yeah, we'll give you a phone call, but we'll just take it over to the court. And so I kind of left it at that. So that's why there's that time.
All right, thank you. Sir, what is it that you want to say?
Well, I filed it because I've never once threatened her ever in my life. Matter of fact, since our almost 30 years of being together and married, I've done anything and everything I can to support her. Bought her vehicles, bought her a motorcycle, gave her money to pay off credit. I tried to be the best husband I could. Now, I did screw up back in the early beginning, that I admit, but nothing physical with her. I never threatened her with any type of harm. So to address the situations from the time going on is I had been pretty much out of that house since the 1st of December. There was very minimal contact between us. Matter of fact, majority of the contact was on her end, whether it be for bills, whether it be for taking her to work, giving her a ride home. That's the only time I've ever been to her work, was when she needed a ride, or I took her food. Matter of fact, just before Christmas, during the snowstorm, she was driving her son's vehicle and was having issues with it. And it was snowing like heck that day. She called me, wanted help. My son and I showed up to help her, offered 3 solutions. She got upset, said her mom's on her way. Okay, cool, no problem. We left. Anytime there's ever been any type of uprising out of me is when she has poked the bear and poked the bear and poked the bear. Like the argument leading up to that night of, or the next day of me going to the house was that she asked me about our medical insurance, because through my work, since I've been there, I've had medical insurance on her. And she wanted to know if medical insurance changed. I said, yes, it did. You knew this back in October. And you did the research and said it was a worse health insurance than what I had before. So you knew all about it. Then she just come unglued on me about how I messed up her infusions. Like, all you had to do was simply ask me for a picture of the card, or I could have gave you a card they sent me too. And she's like, my name's probably not even on it. Yes, it is. I'm legally bound to carry medical insurance until our divorce is filed. So a lot of these arguments have been her calling me, texting me, blowing up on me to get a reaction out of me, which I've tried not to give a reaction at all, knowing how things are. And that's it. And then when she talks about shutting my cell phone off and say about the bill, I just gave her a few days earlier $140 to pay for my cell phone bill. And like I said, I brought up in the past about money I had given her to pay off credit cards twice, so $1,500 a piece. I gave her $1,650 to put down on a motorcycle that she wanted. I've done all these things, all her lemonade stand and dirty soda and crafts and everything else, even though I don't do crafts, but I supported her in it. I got frustrated because, this is years ago too, not anything recent, but I've done nothing but support this woman and her children, all 4 of them. I still keep in contact with one right now who wrote a statement on my behalf of her experience, because she's 8 months pregnant, and, I don't know if we can have witnesses or whatnot here. So anyways, leading up to that was the whole thing about the insurance. So I go to the bank to pull records, because I did have therapy. She asked me for a ride to put winter tires on her car that day. And I said, I can't, because I have my therapy appointment and I have my sleep study results I have to go to. Well, she got all upset about that. I have 2 doctor's appointments, I can't help it. Call me on a whim, taking care of my stuff. I've been going to therapy since October. I've been going to a psychologist since November. And dealt with a lot of things, but I've never once threatened to hurt anybody but myself when I hit my low point, my ultimate low point. And when I had found some stuff out that she was doing, that she denies, but whatever, that's neither here nor there. But I hit my low. And it's been everywhere but up since then. And as for the guns, I do own 3 firearms. I own a 10mm Smith & Wesson that is at my son's house, in his gun cabinet, a 12-gauge shotgun that I bought while we were together, and a 30-06 hunting rifle. That's it. Did I own prior handguns to that? Yes, I did. But the fact that she doesn't realize is that 2 of those guns I sold to Ace buyers in Traverse City to either pay a couple bills, or the last one was to buy stuff for her birthday. So I no longer have those 2 firearms. One was a Springfield XDM, and the other one before that was a Glock. I haven't had them in years. So, and I purchased everything 100% legally, went through the background checks for my CPL. I have no prior history of any type of violence. I worked in fire and EMS for over 15 years. Yep. There's a lot of PTSD from that and my growing up. I haven't touched drugs since February 15th of 2001. And that's when I moved, and after that, I moved up here in November of 2001, because I actually worked for a repossession company, and he wanted to open an office up here. I've been up here ever since. I've been able to pass any type of test ever on the whim. I don't drink alcohol. Very socially, if that, because I know I enjoy it too much. I just don't do it. It's easy for me to, I dealt with my demons years ago when it comes to, drugs. I fought hard. I almost lost my kids. I had supervised visitation with my
And
kids.
that, honestly, like, I don't, to me,
Yeah.
that's your past history.
Yeah, I have no history of violence whatsoever, no history domestic, nothing. This is my third divorce, her fifth divorce. And in all those cases, I've never had anything like this happen. Now, when I did show up that day, because I told her all along, I'll have my stuff out by February 3rd before our divorce. She said, okay. So that day that I went over there, the 25th, is it? When I was actually served, I had no idea, none whatsoever. And when she told me that she had a PPO against me, I said, prove it. That's when she called 911. That's when she come around the corner, started yelling at me. And of course, I'm gonna respond back because I gotta talk over her because that's how she deals with stuff. She's the one that has threatened me, rearing her fist up and everything else throughout the course of our marriage. Up and down, her got a statement. And so as soon as I read that you signed this order, I turned around and walked away. My son was there to witness everything. He's seen her push me, he's seen her, everything else. Okay, fine, I left. Nothing else. Did I have a few choice words? Yes, I did, because of the situation and the lies and everything that she says that I've done to other family members and fabricates, and I haven't done any of this. I have pretty much kept no contact unless because honestly, I was trying to do a no contact to hopefully get her back at one time. I love her, care about her. I've always put her needs above my own. She had thrown bills in front of my face because, when you have a $900 a month electric bill alone and you make, double that a month on top of paying the other bills, yes, I got behind. I did, but I was always robbing Peter to pay Paul. To keep her and her son and her daughter, when she lived there at the time, made sure everything was taken care of the best I could. My car got behind, my motorcycle got behind.
And that, again,
Yeah, I'm just saying, I'm trying to lead up to, where all this hostility comes from for no reason. I've never been the hostile. So with the dog, I did take my dog because she threatened to get rid of him. And she's got 3 other dogs that she neglects to mention that she is threatened to get rid of too. So I took my dog, and my dog went to my son's house before I left the house. Because I was worried about her getting rid of him. He's my buddy, he's my best friend. She has 3 other dogs she forgot to mention. And she's told her daughter that she threatened to put her daughters asleep if she didn't take her. Supposedly her ex-husband Jason's supposed to take the other one. And then I don't know what happens with the white one, which I don't know. So these are things, leading up to that she wants to use against me, but there's always a reason why the actions that I do to prevent anything like that. Like I said, that one night I did hit rock bottom. I was in therapy before that, but I was just so overwhelmed with stuff that I found out. Okay. And I have not been that way since. I go to therapy every single week. I go to my psychiatrist every other week. They put me on 2 different medications for which I found out I had ADHD. I never knew I had that, So now I know what her son feels like, where in my head, it was just everyday life. But now, so I've been on medication for ADHD and my depression, and everything's been going great. Life's been going good. And I didn't know anything about that PPO since, and I have not contacted her, nothing. She's upset because I still have a cell phone that she shut off that I've had with me to give back to her. I was kind of using that as, I want my stuff, my kids got stuff there, in the garage. The only stuff I ever took out of the house was work clothes, a couple personal, like this shirt, and my medication, and a few personal hygiene products, and my guns. Because she wanted to know where they were, because I was told that she was selling my stuff. So I don't know how much of my stuff I have left. I don't even know if that's true. They could have made that up. I don't know. She might not have sold anything. It's just what her family's telling me.
Okay, thank you. Mr. Record. anything else that you want to say?
Well, Your Honor, there's a lot of he said, she said, of course, in reference to it. The point I want to make out is, there's things that he's openly admitted in reference to why I initially filed the PPO order. He also admits to coming over to the house and that there was a verbal argument, that it wasn't pretty. And I'm not saying he's ever physically laid a hand on me. What I'm saying is it's a verbal altercations, the slandering, the things that he's saying, the hostility behind it in my home, in front of my face, on my phone, all of the things is what is concerning, knowing his mental instability, hoping that he turns it around. I wish nothing but the best for him. That's all I've ever wanted for him. But what I'm saying is amongst him trying to do that, I need to be left alone. I want to feel safe in my own home. I want to feel protected. And like I said, there's audio recordings where you can hear his demeanor and his tone of voice versus how he's speaking here for a clearer understanding of the things that I've encountered and had to deal with.
Well, look, I mean, I know nobody's talking to me here in this courtroom the way that you talk to each other in your own home. So
Yes. What I'm saying is that, I don't want to have these altercations anymore. I want it to be done and over with. I understand that, he's a former firefighter, as am I. I understand that he's an EMT, and I understand that he likes to hunt, and therefore he has a CPL and he wants to keep it. But there's a consequence sometimes for actions, when it comes down to forms of domestic violence. Quite frankly, I've had my fair share of it, and the way that this ended up turning out to be is another form of it. Even though it's only verbal, it's still a form of domestic violence, and I've literally had it the majority of my life, and quite frankly, I'm exhausted from it. I'm very, very exhausted from it.
Can I just say one more thing real quick? Once this is over and I get my stuff, I guarantee you there will be absolutely no contact, because I want the same for her. I want her to feel safe in her home. I want her to live her life and me live my life. I have no ill feelings at all. I just want to move on. I want my stuff. And that's the only time I've ever been there, or, anything. I want my stuff.
Okay.
And I promise you, there will never be a problem from my end in the future. So.
That brings me to my next question, because, one of the things we have here is, Ms. Precourt's, you're asking the court to finalize the divorce today. And it sounds like we have some issues. What property do you believe is still at the house that you get?
Well, Your Honor, all my clothes, I literally live out of a gym bag. My clothes, my personal items such as, like I've got an RC car there. I've got motorcycle parts there. My son's got stuff there. Generator, lawnmower.
All right, everything that you accumulated over the last 11 years.
And I'm more than willing to be fair about stuff. But I have sentimental stuff from my mother when she passed away, and just stuff like that. I don't plan, and I told her before, I said, I don't want any of the furniture. Oh, my bed, my dresser, my nightstand, that was my mother's from when she was alive. Like I said, she passed in 2010 from cancer. And it's just stuff like that. There's nothing major,
All right. What about, you guys have debts that you need to divide up?
No, she has hers.
There are bills that are in both of our names, utility bills, and I paid for them the last month. They are due again. I believe I have them with me in reference to his name is on them, my name is on them. So
what about the house? Is that in both of your names?
The house is in my mother's name. My mother owns it.
Okay, so that's not an issue.
And honestly, Your Honor, it's never been an issue.
No, I'm just trying to understand the property issues
gotcha.
here and what we can do to facilitate things being divided up. And when can you retrieve your personal property? Do we have agreements on what's yours and what's not? So what do you say about that?
And throughout our marriage, he's had his bank account, he's done his thing, I've done my thing. We've kind of commonly paid certain bills. Sometimes we put money together, that kind of a thing. I know that he has debt that occurred before we got together. As far as his debt since we got together, that's his and mine is mine kind of a thing. I was willing to kind of go through and split everything 50-50, but what I will say is since all of this happened, things started coming up missing from the home, whether it be something inside the house, outside the house, whatever. I would like to assume that it was at times when he showed up and I wasn't there to get some of his stuff. I've never changed the locks. The doors have been open, that kind of a thing, until the PPO order. You know, there were times when we both wanted to get together and actually go through stuff. This was before it kind of got ugly here. I was willing to give him whatever he wanted. Some of the stuff that he is speaking of is sitting at the house. It's been sitting there. His clothes are in bags waiting for it to be picked up. But there are other things like a generator or a salamander or things like that where we pulled money together for that, and therefore it is marital property and it should be divided accordingly. What I will say is that, yeah, he's had healthcare insurance on me. I have a rare autoimmune disease that costs, my one infusion alone cost over $200,000 a year. Technically, I should be labeled disabled. I should not be working, but due to life circumstances, incomes and whatnot, I've been forced to have to work. You know, it's been a long, lengthy road. And like I said, there's a lot, but when it comes down to him needing his things, I don't have a problem with giving him his things. But there are some things like other assets such as motorcycles that we were selling to my son that's in his name. Motor, you know,
All right,
things.
it sounds like there's more than just some basic belongings here. So here's what we're gonna do for purposes of today's hearing on both the cases. I don't think we're certainly not ready to enter a judgment on divorce today, because it sounds like there are issues that need to be either agreed upon by the two of you, and if you can't agree on it, then I would have to make the decision of who gets what. There's a step that we do in between that called mediation, and that's online, so you don't have to be in the same room together. Wouldn't have anything to do with PPO or anything else, but it's facilitated by a trained mediator. They try to find where the agreements are, where the disagreements are, and then they try to negotiate a settlement between the two of you about who's going to get what. And again, it's an online process, so it's very non-threatening. So I'm going to order that you participate in that, because then you can each go through your list of what you want, what you don't want, things that you both want. They'll try to, you know, find ways to divide those things up so that each of you gets an equal amount of property. So I'm going to refer it to the community mediation. They will be in contact with you to set up a date and a time that works for both of you. My sense of this is that, number one, I'm going to keep the PPO in place until the divorce is final. That way, there's a period of separation. I think, given, you know, the circumstances, I don't think it's a good idea for the two of you to have direct contact. I think if you do it through a mediator, that's a completely different situation. And I think things need to stay status quo until this is resolved from a divorce standpoint. I really get the sense that once the divorce is final here, that the two of you are going to be able to go on your own way. At that point, there wouldn't be any reason for you to contact her. Everything will be divided up. The divorce will be final. There'd be absolutely no reason for you to have any contact with her at that point. That's also going to give you both, in addition to the time that you've had since this was entered, and really since you found out about it, which was only on January 25th, so just a couple of weeks ago. It's going to give some time while we have this mediation process work itself out for the two of you to be separated with no contact and let things cool down. And then once that mediation is completed, which can probably happen within the next month, I'll set this for another hearing. If you've been able to agree on everything through mediation, then we can finalize the divorce. I think at that point, based on what I'm hearing today, I think I may be in a position to, you know, either shorten or terminate the PPO again, because I think at that point there isn't going to be any reason for there to be contact. it'll prevent any contact between now and then, so you have a sense of security. You know, nobody's coming to your house, nobody's gonna be trying to remove any property or trying to contact you directly in any way. Mr. Milan Clement, that's gonna give you an opportunity to kind of distance yourself from the situation a little bit as well. So that's how we're gonna proceed. The PPO will remain in place for now. The mediation service will be in touch with both of you. Then I'll set this for a final hearing. If you're not able to agree on how to divide everything up in mediation, then we'll figure out what are the things that are in dispute. And then, like I said, I'll have to make a decision about who gets what. I would encourage you both, because I think it's always better for people to come to their own agreements about what they're gonna get and what they're not gonna get, instead of having me, who doesn't know anything about either of you, who doesn't really know what pieces of property really mean something to you and which ones don't. Rather than having me just dividing things up, it's better if you, through that mediation process, if you can figure out what's really important to you and what's not, and find middle ground there where you can give up things that aren't important to you, so maybe you can get the things that are.
There, to be honest with you, Your Honor, there's not a whole lot there that I want.
Well, and that's great.
I would rather have it all done today and give her everything but my clothes and my sentimental stuff from my mother. I'll be honest with you, the motorcycle that she is talking about that her son hasn't paid me in over 6 months for it. He still owes me $1,000, you know, and that's stuff that's not, I don't even care about. That is physical. I don't care.
Yeah.
I do want my clothes, I want my son's stuff, and I want my mom's stuff. You know, that's it. I can sign the form today as long as you would agree with it to let me within 2 weeks grab that stuff, because I already got a storage unit and had a U-Haul. And that's why I went over there that day to give her an advance notice that, hey, tomorrow I'll come get the rest of my stuff out of this house, but we never made it to that point.
Yeah.
You know, so I don't care what happens, to be honest with you. There ain't nothing there that I can't live without except my mother's stuff, and I don't want to build a whole new wardrobe.
Yeah, I understand that.
She wants a generator, she can have it. She can have it all. I don't care.
Sometimes the devil's in the details with that kind of thing.
Yeah.
And I mean, honestly, I hate for you to make that decision right now.
I want to wait from her. That's
I
what
know,
it boils down to.
and I get that, but,
There's been a lot of damage and I'm ready to move on.
and I understand, but I don't want you to make that decision now in the heat of the moment.
Yes, sir.
One that later you might regret, whereas if you have some time to think about it, go through this mediation process.
Okay. Yes, sir.
I think that's gonna have a better result for both, honestly. So,
Okay.
so that's how we'll go forward. Sir, I'm just gonna have you remain here for just a minute, let her vacate the courtroom, and then you'll get notice of that next year.
Okay. Sure, thank you. Where do I update my address?
You can do that with the clerk's office,
With the clerk?
or right here.
Yeah, if you want to give it to me.
Yeah,